Good morning, everybody. Thank you for joining our morning webinar here on Friday, June 19th. We will be talking about some updated PPP loan forgiveness applications today, as well as some other recent developments. My name is Erik Daly. I'm a member in Miller Johnson's corporate group. I practice mainly in the area of mergers and acquisitions, but over the last 3 months or so, I've been pretty deep in the CARES Act, and part of that is the Paycheck protection program, of course. So we've been doing periodic webinars on PPP, the Main Street Lending Program, other CARES Act related topics alongside of our more state-specific employment law, executive order issues. Today we're going to be talking really just about the PPP and some recent developments. But before we get into that, I'd really like to just start off by reminding myself anyway, and others in the Miller Johnson team who are often on the webinars with me that, we're approaching this webinar series with the attitude of ingenuity, candor, cooperation, and innovation. Just help, develop solutions for clients in the community that we work in to kind of weather this storm and this pandemic. So with that, I'm going to pivot to just a couple, very, very briefly, news headlines. That's another thing we do at the outset of each of our morning webinars. And I don't want to spend too much time on this today because it looks like there may be some questions that we've already received, and I want to get to the PPP program. But suffice to say, there are different experiences across the country right now in terms of statistics related to new cases of coronavirus, deaths. Worldwide, when you kind of take a big step back and look at the trends, the number of new cases is growing, although our experience in Michigan is different than that for the most part. The main areas where worldwide cases are growing are areas like Latin America, Africa, some portions of North America and the United States. And on the whole, there have been 43 countries that have shown trends of overall decline in new cases. So the main reason I mention that is just because there's obviously continued uncertainty around this. As long as there are portions of the world where there are fast growing number of cases or moderately growing number of cases, then there's a continued threat until we have some kind of a vaccine or other approach to kind of systematically deal with containment. So more specifically here in the U.S., we're seeing some of that play out in like Florida and California, where there's been bigger spikes recently in number of cases. So best practices continue to develop as it relates to public policy on that. And then obviously there's a whole slew of workplace related practices that differ across the country. So one other bit of local news to the Michigan audience anyway is that Governor Whitmer said yesterday that she expects, subject to additional safety rules and continued containment of coronavirus in Michigan, that K through 12 in-person instruction would likely begin again in the fall in some form, as long as we continue to have those safety measures and containment in place. So that's, for those of us with children, I think that's encouraging news. As nice as it has been to work from home with them, it'll be nice to see them be able to go back to school, I'm sure. Okay, so with that, why don't we turn to today's topic, the PPP flexibility as a whole. A couple of weeks ago, we'll talk about what happened with the PPP Flexibility Act being signed into law. And we'll talk about these updated forgiveness applications that were published 2 days ago by the SBA and Treasury, really, for the most part, implementing the Flexibility Act. Touch on a few other recent developments, do some Q&A and conclusions, and then briefly mention our Miller-Johnson Audit and Compliance Preparedness Program before we conclude. So with that, why don't we move to the next slide, please? Thank you. The PPP Flexibility Act, just very quickly, folks who have been tracking PPP probably aware of a lot of this already. This was signed into law 2 weeks ago after overwhelming bipartisan support in Congress, and it made a variety of changes to the Paycheck Protection Program, which were designed to give borrowers more time and flexibility in how they use their loan on a forgivable basis, and to make staffing or restaffing decisions accordingly. Over the last 2 weeks, SBA and Treasury have been updating, the guidance, rules, forms, et cetera. I don't think they're all the way there yet, but we can go to the next slide. There have been some concrete things that they've done to implement some of these key changes under the Flexibility Act. And again, I'll go through this quickly because we've covered it in a prior webinar, but these are really the main things that are being implemented into the updated application forms, plural now, and some other guidance. So just to go through this very quickly, the Flexibility Act extended the 8-week loan forgiveness period to be either the earlier of 24 weeks or the loan origination date through the end of this year. Although borrowers who already had loans, PPP loans, before the Flexibility Act was signed into law on June 5th, are able to opt to continue to use that 8-week period if the circumstances are right for that, and touch on that later. The Act reduced the minimum payroll cost spending requirement from 75% to 60%, so that the portion of the loan that is forgivable, 60% of the forgivable portion must be payroll costs. There have been some concern that based on the new language in the Flexibility Act, that it was the 60% would be sort of an all or nothing test or a cliff kind of threshold test, so that you had to spend 60% of the loan proceeds on payroll costs in order to achieve any forgiveness. And subsequent guidance and rulemaking and now these application forms all confirm that is not the case, and that a borrower who spent 59%, say, of the loan on payroll costs would still be eligible for most of the forgiveness. It would just be proportionately reduced based on the shortfall compared to that 60% target. The Act extended the June 30th safe harbor date for rehiring or reinstituting compensation level that may have been reduced, extended that date from June 30th to December 31st of this year, and we'll touch on that later because there's some language in the application forms that changes that a little bit, largely to give borrowers more flexibility. The Flexibility Act prolonged the deferral period and repayment periods for loans. So new loans originated after the June 5th date have a 5-year maturity instead of the original 2-year maturity. Loans that predated the Flexibility Act, unless an alternative arrangement is worked out with the lender, which is permissible, those prior loans still have a 2-year maturity. Although the deferral period for payments on all loans was extended from 6 months to basically 10 months after the end of your covered period if you haven't yet filed for forgiveness. So you have a longer payment deferment period. And then the last change, which we're not going to spend a lot of time talking about today, is there had initially been an exclusion under the CARES Act for PPP participants to be able to utilize payroll tax deferral provisions, and that's been eliminated under the Flexibility Act. So you can use the PPP and get the benefit of that deferral into 2021 and 2022. Next slide, please. And then a couple of other points from the Flexibility Act, which we'll get into more detail on when we talk about the new applications, is that there was really two new safe harbors added for full-time equivalent employee reductions, so that certain reductions would not count against the borrower's loan forgiveness calculations. And one was basically if you were unable to rehire an employee who was employed at February 15th, and you couldn't find some similarly qualified employee to fill that position, a new employee to fill that position, then you get a kind of relief for that. And then a broader, more general one is this inability to rehire back up to prior levels because of new Health and Human Services, CDC, or OSHA compliance requirements implemented between March 1st and the end of this year. And we'll get on talk about that one more later as it relates to the application, but it's potentially a fairly open-ended exception. Next slide, please. Okay, so that's the backdrop for these updated loan forgiveness applications that were posted a couple of days ago. And the first thing I should say, it's not mentioned in the slides here, but the loan forgiveness applications would be very helpful for people for borrowers to look at and start seeing what information they may need to collect. But you should also work with your lender before you try to submit anything, because each lender is going to have their own process set up for accepting forgiveness applications and reviewing them. And so just anecdotally, I know that some lenders have said, even though the application forms may be available, they won't be accepting loan forgiveness applications until, say, July, for example, or some other similar date. So you should communicate with your lender about kind of what their approach to accepting applications, loan forgiveness applications is, because they obviously need time to implement the instructions here from SBA as well. The big picture is there's a new loan forgiveness application form, or the Form 3508EZ. We'll just call it the EZ application form, and some related instructions for borrowers that will not experience any reduction in their forgiveness based on full-time equivalent employee or compensation reductions. So basically the approach that was taken here is that if you're a borrower who knows there won't be any reduction because you maintain compensation levels and employment levels or qualify for one of the safe harbors, there's no reason for you to need to fill out a bunch of detailed schedules on the full-length form that a borrower who did have pay cuts or did have significant changes in employment levels would need to provide to the SBA to calculate the reduction in loan forgiveness. So if you're eligible for the full forgiveness because you didn't change anything about your employee comp or employment levels, then you may be eligible to use this new EZ form, which does require fewer calculations and somewhat less information to be provided to your lender and ultimately the SBA. The original loan forgiveness application, kind of the longer form, has been updated, but it is really not dramatically different compared to the original version, other than incorporating the Flexibility Act provisions and a couple of the new safe harbors. Next slide, please. Okay, so as I alluded to before, this EZ loan forgiveness application is generally available to to borrowers that are not experiencing reductions based on employee levels or compensation. So there are three standards that a borrower could qualify under to use the easy loan forgiveness application. The first is pretty straightforward. It's a self-employed individual, independent contractor, or sole proprietor who had no employees at the time that they applied and did not include any employee salaries in their loan computation. So this could be, independent contractor, like a real estate broker, for example, who operates as an independent contractor and has no employees. That's the kind of person that would qualify under this first standard, among others, but that's an example. It could be because they don't have employees, they couldn't have employee reductions or, reductions to employment compensation levels, so they should use the form easy. Next slide, please. The second and third standards for qualifying for the easy loan forgiveness application are a little bit more complicated, but the underlying principle is really the same. You start with the idea that the borrower did not reduce compensation or wages of any employee by more than 25%, because you're allowed to reduce compensation by up to 25% without impacting loan forgiveness. So as long as you're within that 25%, that's what you're looking for, and you exclude people earning more than $100,000 a year. In addition to that, under the second standard for eligibility, you would have to say that the borrower did not reduce the number of employees or the average paid hours of employees between January 1st and the end of their covered period. So that's really what we talked about before. No reduction in FTE levels, no impactful, when I say impactful, I mean loan forgiveness impactful reductions in compensation, so more than 25%, then you would be eligible for the easy. And when you're looking at whether you're eligible to use this standard, you would ignore any reductions that arose, again, and this is where we start to implement the new safe harbors from the Flexibility Act. You would ignore any reductions that arose from an inability to rehire people who were employees on February 15th if you were unable to hire similarly qualified people to fill those positions before the end of the year. And you would also ignore reductions in employee hours if you offered to restore those hours, but the employee declined the offer. So there's kind of mini safe harbors within this second standard for qualifying for the easy loan forgiveness application. Next slide, please. And then the third standard is very similar to that second one. You start again with the premise that the borrower did not reduce compensation levels by more than 25% during the covered period, again, excluding those earning more than $100,000 a year. And then you look at whether the borrower was unable to operate during the covered period at the same level of business activity as before February 15th, 2020, as a result of compliance with requirements or guidance established after March 1st of this year by Health and Human Services, CDC, or OSHA, related to sanitation, social distancing, or other work or customer safety requirements related to COVID-19. And this ties back to kind of the original summary we went through of the PPP Flexibility Act and one of the new safe harbors. So again, there's this safe harbor, kind of a mini safe harbor for qualifying for the easy loan forgiveness application. And this one is on its face very open-ended, the way it's been written here. And I think some more guidance will be needed about what this means. But a borrower being unable to operate during their covered period at the same level of business activity as before February 15th, due to these issues, it seems, one, I think we need clarity about whether kind of state and local related implementation or parallel restrictions or safety requirements are similarly a rationale or a justification for qualifying here. But also, what does same level of business activity mean? Does that mean you have to show some decline in revenue or some other metric, or does it just mean that, people couldn't come into the office? So depending on how this gets implemented by SBA, this could be a very open-ended qualification for the easy loan forgiveness application, assuming that any employee reductions did relate to not being able to maintain the same level of business activity. So we'll have to continue to follow that, but at least initially it looks like this is to be interpreted somewhat broadly. Next slide, please. So, why would you want to use the easy loan forgiveness application? Because as we talked about, the underlying rationale or principle here is that the application is for those who won't have their loan forgiveness reduced due to employee or compensation reductions. Much less information is required to be provided with the application related to those topics, and there's no worksheets that are attached where you calculate how much of a full-time equivalent employee somebody counted as based on their average hours, or how much the compensation reduction amount attributable to any given employee is. It's it's a much more concise application, although you still must certify as to your eligibility, and in some cases, depending on which of those standards you qualify under, you may need to provide some information kind of supporting your rationale for qualification to use the easy loan forgiveness application. But this application form really cuts back on a lot of the employee by employee level calculations that would need to be used or need to be submitted along, need to be calculated before you submit the full standard, I'll call it full length loan application form. Having said that, the borrower, even if they use the easy loan forgiveness application, still needs to retain their complete PPP loan file for 6 years after full forgiveness or repayment of the loan. And the SBA still has the right to request or audit any relevant information. So I just want to emphasize it's not the kind of situation where you can just submit the easy application and kind of walk away and forget about it. There's still some tail obligations and potential for the SBA to request supporting information. Next slide, please. And as it relates to the what I'll call the standard loan forgiveness application, if you don't qualify for the new easy application form, then you still need to use the lengthier loan forgiveness application, which looks a lot like the original version of this loan forgiveness application that was published by SBA back in May. Other than it implements the Flexibility Act provisions related to payroll costs, some of the new safe harbors, and a handful of other things, which we'll touch on. Why don't we go to the next slide, please? So these concepts that I'll go through over the next few slides relate to both loan forgiveness applications. So these are changes to the standard loan forgiveness application, or in some cases, things that remain the same. In addition to applying to both the full length loan forgiveness application, these concepts equally apply to the Form Easy as well. Both applications still require borrowers to check the box if their loan amount exceeds $2 million when you combine that with affiliates, with their affiliated entities or individuals' PPP loans. So, if you're above that amount, together with your affiliates, you need to flag that for the SBA because those loans are subject to potentially heightened review and some level of audit per the prior SBA guidance and rulemaking. Both applications continue to have this alternative payroll covered period concept retained, which means, which means that if your payroll period is biweekly or more frequent, then you can choose, for purposes of calculating your payroll costs, you can choose to use an 8-week or a 24-week period that essentially aligns with your payroll periods. I'm oversimplifying a bit, but it gives you better harmony, I guess, is maybe the right way to put it, between your covered period and your actual payroll periods for purposes of calculating payroll costs if your payroll periods are biweekly or more frequent. In any event, your covered period or your alternative payroll covered period can't go past December 31st. However, that's presently the hard stop date for all these calculations. And then for 8-week borrowers, the amount of forgivable employee cash compensation is still $15,385 for employees where they're an 8-week borrower. For 24-week borrowers, as it relates to non-owner employees of the business, that amount is just tripled for 24-week borrowers, so that up to $46,154 could be forgivable. We'll get to in a minute how that's a little bit different for owner employees and self-employed individuals, but at least as to non-owner employees, you can basically triple the amount of forgivable cash compensation. Next slide, please. Okay. Both application forms also implemented a change to reflect the employee level and compensation reduction safe harbors for restoring FTE levels and compensation. And interestingly, the instructions to both applications potentially modified the time at which you would measure that restoration of FTE levels or compensation. Under the Flexibility Act, that restoration date was just moved from June 30th to December 31st of this year. However, the application instructions for the restoration provisions, both for full-time equivalent employees and compensation, now provide that the relevant measurement date is the earlier of the date the loan forgiveness application is filed, or December 31st, 2020, whichever is earlier. So it's not entirely clear what all the implications of that are. I think some are interpreting that to mean that you don't need to wait out your full 24-week period before you submit your loan forgiveness application. I'm not sure that's right. I think we need more guidance on this. It may well end up being right, but you could have a situation where an early PPP borrower's 24-week period ended before December 31st, 2020, and they could go in and submit for loan forgiveness by filing their application. In that case, this provision could just mean that they don't have to wait until December 31st, 2020 to do that, although they still have to wait out their 24-week period. So we'll see. We need more guidance, but this change potentially gives borrowers some meaningful flexibility to manage their employee and compensation restoration to qualify for that safe harbor. And I'm sure that the SBA will issue some additional forgiveness guidance related to these topics. Just if their past practice, at least on the loan application and some other issues, has been to issue the application or the document, kind of see what questions or issues arise out of that, and then either through FAQs or updated interim final rules address some of those issues. I think this is one where we'll just have to keep an eye on it. And I know it's one that a lot of clients have asked about. So I think there's a potential here that there might be more flexibility that's helpful in that regard. Next slide, please. Okay, and then I kind of alluded to this before. There are some owner compensation limits for forgiveness that relate to owner employees, which is not defined under any of the legislation or rulemaking. Self-employed individuals and or general partners. For 8-week borrowers, there's really no meaningful change here. The owner compensation is limited to 8 weeks of 2019 compensation, subject to an overall cap of $15,385. However, if you're a 24-week borrower, owner compensation is not just tripled. The forgivable owner compensation is not tripled. It's actually limited to 2.5 months equivalent amount of the individual's compensation from 2019, subject to a cap of $20,833, which is 2.5 months equivalent of $100,000 per year. So you can contrast that with the approximately $44,000 cash compensation number for non-owner employees. And the SBA and Treasury provided some rationale for this, which I won't get into in detail, but basically there was some concern that this could lead to, if you had allowed owner employees or self-employed individuals to forgive up to the $44,000 amount, that there could be some gamesmanship given the expansion of the safe harbors for employee reductions. And they were of the view that Congress's intent was not to allow for that result. So they're limiting owner employees, self-employed individuals, and general partners who use the 24-week period to that cap of $20,833 as a maximum amount. And one important thing that is mentioned in the interim final rules that the SBA has issued is that these limitations for owner compensation apply in the aggregate across all businesses that the relevant individual is receiving owner compensation from. There's no mechanism or disclosure in the application form that would ferret that information out. So that's something that the owner employee, self-employed individual, or general partner will need to track on their own and coordinate with the company if they're an owner employee or a general partner to make sure that if they're receiving owner compensation from multiple businesses, that they don't go through that aggregate cap. So that's just something for people to be aware of if they have an ownership interest in kind of multiple businesses. Next slide, please. And then a little bit more guidance related to self-employed individuals, general partners, and owner employees. The application forms both make clear that payroll costs for these individuals do not include healthcare benefits, nor for self-employed individuals or general partners do they include retirement benefits. However, retirement contributions in relation to owner employees only are eligible for forgiveness, subject to a cap equal to again 2.5 months worth of that same owner employee's 2019 retirement contribution amount. And it's a little unclear to me whether that in that situation for an owner employee seeking forgiveness on a retirement contribution amount, whether that counts toward their overall cap on owner compensation or not. So I think that's something that the SBA may need to clarify. It would make sense to me that it doesn't, but not everything about the PPP makes sense. So we'll see. Next slide, please. Okay, so let's hit on a couple of other recent developments beyond the application forms. The SBA also published updated borrower and lender application forms. So these are forms related to actually new PPP loans that are originated. And largely they just implement the program changes required by the Flexibility Act. So some of the certification language has changed to reflect the 60% payroll cost requirement instead of the 75%, things like that. And there were not any wholesale changes to the forms. The program changes also are, in addition to the application forms, are memorialized in an interim final rule that the SBA issued about a week ago. And that didn't get a lot of attention, just again because it really just reflected what had already been announced or legislated by Congress. It was really just kind of refreshing some of the older interim final rules the SBA had already issued to be consistent with the Flexibility Act. One thing that did change substantively that's not part of the Flexibility Act is that based on some feedback from Congress, and in particular the Small Business subcommittee or committee in the Senate, the SBA issued an interim final rule to relax eligibility requirements to allow more PPP loans to businesses that are owned or operated by those with past criminal records. So let's go to the next slide, please. Basically, the upshot of this is that the look-back period for various, we'll say bad actor disqualifiers, put bad actor quote unquote, is that the look-back period was shortened from 5 years to 1 year to determine eligibility for PPP participation, whether because it's an individual borrower or a 20% or greater owner of a borrower. So for some businesses who may not have been eligible before due to part ownership by somebody who, had a criminal issue that disqualified them before, they may want to revisit this to see if they're now eligible. There's an exception to that shortened look-back period. However, for felonies that involve fraud, bribery, embezzlement, or a false statement in a loan application or an application for federal financial assistance. And in those cases, the look-back period does remain 5 years because it kind of directly relates to, and bad actors, quote unquote, in the context of financial fraud or alleged financial abuses or misstatements in loan applications. And then the updated borrower application also eliminates pre-trial diversion status as a criterion affecting eligibility. And these changes also, they were based on some political input from Congress, but also in the context of litigation by the ACLU to try to strike down these eligibility criteria altogether, which is ongoing. So just something to keep in mind if you had a borrower who is ineligible before, but may still be eligible for these last 11 days of PPP loan availability. Next slide, please. So to wrap up today's discussion, SBA and Treasury have made some pretty good progress in updating the core framework. If you think about it, it's sort of a house that they're remodeling here. It seems like they've got a lot of the core framing in place to reflect the new rulemaking and updated terms of the Flexibility Act, although there's still work to do. And there's, in my mind, a fair amount of murkiness, in particular related to the owner compensation issues. Who is an owner employee? You know, does somebody who owns 1% of a company who's a PPP borrower qualify as an owner employee? There's just more guidance needed to understand that better. And then in a couple of more granular areas, we know that the SBA is planning to issue more guidance, things like the forgiveness-related updated interim final rule, guidance on how borrowers need to report employees who turn down employment or rehire offers to state unemployment agencies. They've said they're going to provide guidance on that. Similarly, they've said they're going to provide guidance about an appeals process for adverse loan forgiveness determinations. So there's definitely more to come, and the long and winding PPP road will continue. So with that, I'm going to look in the Q&A dialogue box at this point to answer a few questions. And why don't we move to the next slide while I'm doing that? That'll include some information about our PPP compliance readiness program that you can look at. But basically, we have a flat fee program at Miller Johnson where we're working with client borrowers or any new client borrowers who have PPP loans, and we're just really helping to proactively build the record for compliance and develop some best audit practices, best compliance practices for them to be able to try to navigate this constantly changing landscape as best as possible to position themselves for a clean review when their loan, if and when their PPP loans get audited. So I'll leave that up while I turn over to the Q&A. One question that came up: are you able to choose a period prior to the 24 weeks? For example, if we're able to use our funds properly in 12 weeks, can we apply for forgiveness at that time, or do we need to wait 24 weeks? So I touched on that a little bit, and this question, it looks like, came in before we got to that slide. We'll see. There's some language in the application form that suggests there will be that sort of flexibility, but it's not. And if that was the intent, they didn't hit the nail straight on the head, if you will. And so I think we'll have to see if there's updated guidance on that point. It may well end up being the case, but if they do that, it will vary from what the statute actually provides for kind of the loan forgiveness calculations. But that has not stopped the SBA or Treasury in the past. So they've been open to deviating from the actual statute. So that's an important question, I know, for a lot of borrowers. And I'm sorry, I don't have an answer right now. This question came up a few times. I'm going to skip through, just make sure that I'm not missing anything. Okay, here's another question. Do headcount reductions due to performance issues or retirement count against you for loan forgiveness? There are exceptions for voluntary resignations and terminations for cause. So not any performance issue necessarily. And of course, cause is not defined, in this context by the SBA. So you need to keep track of these things and have good record keeping. But if there's a for cause, let's say, willful misconduct by the employee or some other reason that you would consider a for cause dismissal or voluntary resignation, as long as you keep the right record keeping of that, they will not count against. There's some caveats that go along with that, but just keep good records of those things, and you should be able to get some relief for at least a retirement issue. related to the third standard for the easy loan application, does only being able to provide product to essential customers under Michigan rules qualify? How does the borrower prove that they meet these standards? Those are great questions, and unfortunately, I don't have answers right now, other than to say that this is related to the qualification for not being able to conduct business at the same level as February 15th based on safety requirements. And they specifically called out Health and Human Services, CDC, and OSHA safety requirements. I think the language could be read to also apply to state and local executive orders and the like. But I just want to keep good records of, how you were impacted by those safety requirements, whether they be the federal ones or the state or local ones, and kind of what the negative impact on your business was. There's really just not a lot of specific guidance about what that safe harbor means at this point. So for now, I'd say the best thing you can do is keep a good record of what the negative impact on your business was and what the triggering safety rule or social distancing requirement was that you could tie it to. If you have a loan prior to June 5th, then your loan has to be paid back starting 10 months after it was given. Question, it has to be paid back. Okay, so there's a little confusion on this one. If you have a loan that was originated before June 5th, you don't have to start paying it back until 10 months after the end of your forgiveness period, but it still has a 2-year maturity at that point. So you have a payment deferral for up to 10 months after your forgiveness period ends, and then the loan would need to be fully repaid to the extent it's not forgiven by the 2-year anniversary of its origination, unless your lender agrees to extend the maturity date to 5 years. There's another question here that I think we touched on and I don't have an answer to, unfortunately. You mentioned that the maximum payroll is $46,154 for non-owner employees. Is there a level of ownership that is not considered an owner for this purpose? For example, we have a lot of owner shareholders, quote unquote, who have less than a 2% ownership interest. Will their maximum payroll be something other than the 46,000 number? I don't know. The SBA has not said what level of ownership qualifies for an owner employee. They've just thrown around the phrase owner employee. So I expect we'll need to get some guidance about what that means. Hopefully it doesn't mean that somebody who has 1 or 2% ownership is considered an owner employee, but rather it's more along the lines of what they consider an owner for purposes of the loan application, which is a 20% threshold. But hopefully it's something closer to that, just in terms of administrative convenience, which seems to be a priority for SBA based on the kind of the pushback to the original loan forgiveness application. So unfortunately, we don't know right now. Hopefully there's 1 or 2 of these questions that we do have answers to, and I know there are a lot of open-ended issues right now. I'm just scrolling through the questions here. Here's the one. Can C corporation shareholder employees get the health insurance in addition to the wages? I think we need more guidance on that one. There's part of the application, that updated application form that only references S corporation shareholders as being subject to some of the restrictions, but then that qualifier is not used consistently throughout the application forms, so that may or may not have been intentional. So it's not clear to me whether C corporation owner employee would be able to include both, just because they really weren't consistent in how they, again, ties back to not really having a definition for owner employee. So we're gonna have to wait and see on that one. There's another question, whether there's a definition of owner compensation. Touched on that. Unfortunately, not a very good one, and with lots of holes. So that's a big area of murkiness, as I mentioned before, that they're going to need to clarify. We've got a few minutes left here, so I'm going to try to do as many of these questions before 9 a.m. Eastern as possible. Okay, just to clarify, this is a question, just to clarify, if you elect the 24-week period, does this allow you to get more than 8 weeks of your payroll costs forgiven? Yes, potentially. You could use it. You could seek forgiveness for costs over a greater period, even though kind of your original loan calculation was sort of based on an 8-week period. Because of the way the program's evolved, you now have, if you stick with that 24-week period, you could use it over a longer period of time, and you could use it all on payroll costs, and that would probably be the easiest way to document forgiveness over longer than an 8-week period. So yes. Here's another question. If you take out a PPP loan after June 5th, can you still elect the 8-week period for forgiveness? No. The 8-week period is only available to those borrowers who already had PPP loans prior to June 5th, prior to the Flexibility Act becoming law. Okay, so here's a question that has come up before. When we're talking about safe harbor and wage reductions, is it based on the rate of pay or the gross earnings? For example, we did not reduce the hourly rates of employees, but they may have worked fewer hours, which creates a reduction. Do you know which interpretation is correct? So they're standalone metrics. So you don't have a wage reduction just because of a reduction in hours, as long as you keep the hourly rate of pay the same, or the average kind of weekly salary the same. So you don't get kind of, the SBA has been very clear at least about this, so they're not intending to double penalize borrowers who, they're not intending to create a compensation reduction issue because of a reduction in hours alone. You'd have to also have a reduction in the rate of pay, whether it's hourly or weekly or biweekly. I'll do one or two more questions here. Sorry in advance that we won't be able to get to all of them. If we are able to operate as normal the entire year, no employee or salary reductions, and we qualify for all of the requirements of the Form 3508EZ, can we still use it? Yes. I'm not sure why. There's no, maybe if the question is there some, you should still be able to use it, you know, unless there's something I'm missing about the question. That's really the type of business that it's targeted at, is a business that doesn't have any employee or salary reductions. Okay, I'll just take one more here before we wrap up. There was a question, can we use 100% of our PPP loan to forgive payroll costs? Yes, as long as you do so within your chosen forgiveness period, or if you have the ability to choose your chosen forgiveness, as long as you do it in your 24 or 8-week period, you can use all of it on payroll, and you don't need to use any of it on non-payroll costs like utilities, mortgage interest, or rent. Those are categories of expenses that are not central to, I mean, they're forgivable as long as they don't exceed 40% of the forgiveness amount, but I think the SBA and Treasury would prefer borrowers to use 100% of the loan on forgiveness. It'll make their job simpler in terms of validating that the loan amount is forgivable, and it's also kind of more core to the policy of the Paycheck Protection Program. So I'm going to, unfortunately, have to stop and wrap up now. I do want to thank everybody for participating in our webinars, and they should, of course, if we could advance slides toward the end of the presentation to provide my contact information. You should feel free to reach out to me or anybody else that you have contact with on the Miller Johnson team. I'm sorry I couldn't get to all the questions, but if there's other things you'd like to talk about, here's my contact information and email address, or you can reach out to another Miller Johnson attorney you've worked with, and they'll connect you with me or another one of our PPP focused attorneys, of which we have quite a few at this point, on both the corporate side and the litigation side, to help position clients to navigate this difficult process for forgiveness and to be prepared for any kind of SBA or other agency review. So thanks very much for joining on a Friday morning. I hope people have a great day and enjoy the weekend as well. Thank you.